This information session on foreign investment promotion and protection agreements is presented by Foreign Affairs, Trade and Development Canada. Canada has been negotiating foreign investment promotion and protection agreements since 1989. There are 24 of these bilateral agreements currently in force. The goal of this session is to build awareness of the contents of foreign investment promotion and protection agreements. International investment is an essential corporate strategy for many Canadian companies competing in today's global economy. The Government of Canada seeks to promote Canada's economic prosperity through the establishment of a fair, open, transparent, and rules-based system of international trade and investment. This is done through trade and investment liberalization, which stimulates competition and promotes innovation and productivity gains amongst domestic producers, benefiting Canadian consumers and workers. Canada's trade strategy includes the objective of increasing foreign direct investment in Canada and Canadian direct investment around the world. FIPAs are an integral part of this strategy and are pursued where Canadian investment levels or opportunities for growth are substantial because FIPAs provide the protection and predictability investors need when investing in foreign markets. By investing abroad, companies can gain access to overseas markets, reduce input costs, secure access to key resources, acquire new technologies, and provide better support to customers. Success abroad means new jobs and new sources of prosperity at home. A Foreign Investment Promotion and Protection Agreement, or FIPA, is an agreement entered into between Canada and a partner country for the promotion and protection of foreign investment. A FIPA is a bilateral agreement designed to protect Canadian investors and investments abroad through legally binding rights and obligations. These rights and obligations are reciprocal, that is, they apply to both parties to the FIPA. The risks of investing in a foreign country can be high. Such risks include political instability, weak legal institutions, nationality-based discrimination, uncertain regulatory regimes, and the possibility of expropriation. To help address these risks, the Canadian government pursues a policy of negotiating foreign investment promotion and protection agreements in order to provide a more transparent and predictable climate for Canadian investors abroad. In 1989, the Government of Canada initiated a bilateral foreign investment promotion and protection agreement program called the FIPA program. The goal of the FIPA program was and remains the promotion and protection of foreign investment, in particular in emerging markets. Canada currently has 29 treaties currently in force that contain investment obligations with key trade and investment partners. These include agreements with countries such as Ukraine, Thailand, Lebanon, and Jordan. Today, Canada continues negotiations towards 12 other FIPAs, including Ghana and Indonesia. All core obligations found in Canada's FIPA are essentially identical to those found in NAFTA Chapter 11. Moreover, the core obligations in Canada's FIPAs and investment chapters have been essentially the same since the initiation of the FIPA program 24 years ago. Canada's model FIPA includes the following key obligations. Non-discriminatory treatment is provided to investors of a state party to a treaty and to their investments on both a national treatment basis and a most favored nation treatment. National treatment is treatment in relation to investors of the other party and their investments. This obligation means that both Canada and the partner country must treat investments by investors of the other party no worse than investments by its own nationals. For example, for foreign businesses operating within Canada, Canada must generally accord these businesses treatment that is no less favorable than it accords in like circumstances to domestic businesses. Most favored nation treatment is treatment in relation to third country investors and their investments. This means that for Canadian businesses looking to set up in a country and operate there, such as in China, they cannot be treated less favorably than any other foreign company looking to set up there or which is already operating in that country. Customary international law minimum standard of treatment is provided to foreign investments to ensure that the treatment does not fall below a basic international minimum standard. The breach of this standard would include, for example, the denial of justice in criminal, civil, or administrative proceedings. Protection against direct and indirect expropriation is provided to foreign investments, such that any expropriation must be done for a public purpose, under due process of law, in a non-discriminatory manner, and against payment of prompt, adequate, and effective compensation. It should be stressed that FIPAs do not require governments to compensate investors just because the governmental measure has decreased profits. The government measure must substantially deprive the investor of its investment. Moreover, the mere fact that a measure decreases a foreign investor's profits, even if substantially, does not mean, in and of itself, that the measure breaches the FIPA's obligations. In more recent agreements, a dedicated annex on expropriation clarifies the meaning of indirect expropriation. The annex confirms that legislation and regulations adopted by Canada to protect the public welfare, such as in areas like health, safety, and the environment, do not violate the FIPA's obligations on expropriation, regardless of whether they result in a decrease in a foreign investor's profits. Transparency of legal frameworks applying to investments is promoted. Laws, regulations, and procedures applying to the investment must be published or otherwise made available. To the extent possible, parties are required to consult on new measures. Free transfer of capital and other payments relating to an investment, for example, contributions to capital, profits, capital gains, interest, dividends, or proceeds from sales of investments, are provided into and out of the host country and without delay. Performance requirements obligations usually prevent parties from imposing certain requirements on investors and their investments, such as trade balancing requirements, domestic content requirements, and requirements mandating the transfer of technology. The conditioning of the receipt of an advantage, such as subsidies, on certain requirements is also prohibited. Senior management and board of directors obligations protect against nationality requirements for senior management and board of directors. Compensation for losses obligations provide non-discriminatory treatment in cases where the government provides compensation due to natural disasters or civil unrest. The FIPA also ensures that all investment disputes arising from breaches of the agreed rules are resolved under international arbitration, ensuring that adjudications are independent and fair. If a dispute arises with respect to a measure of a party that breaches an obligation in the FIPA, the other party to the FIPA can bring a dispute under the state-to-state dispute settlement provisions of the treaty. In addition, an investor of one party can bring a claim against the other party where obligations applicable to the investor have been breached. The provisions of the treaty provide direct access for investors to an effective, impartial dispute resolution system through international arbitration. This is known as investor-state dispute settlement. This means that Canadian investors in a foreign country will no longer have to rely on the legal system of that foreign country to have investment disputes resolved. This can be particularly important in operating environments where the local judicial system may not be well developed or independent of political influence. At the same time, it should be noted that investor-state tribunals cannot force a party to the FIPA to change any law, regulation, policy, or practice. The provisions and procedures for investor-state dispute settlement are clearly laid out and emphasize transparency through elements such as public access to hearings and documents. Canada maintains a policy of conducting open, transparent arbitration whenever the Government of Canada is challenged under these dispute settlement procedures. With respect to the actual application of the investor-state dispute settlement under FIPAs, no claim has ever been filed against Canada under any FIPA. Again, all obligations of the FIPA, including the Canada-China FIPA, apply reciprocally to both parties to the agreement. Further, FIPA does not prevent parties at all levels of government from enacting non-discriminatory laws and regulations in the public interest. Parties maintain their ability to regulate and legislate in areas such as the environment, culture, safety, health, and conservation. All investors and their investments, whether domestic or foreign, will face the same requirements with respect to existing local laws and regulations. A foreign investor and their investments in Canada must respect all existing Canadian laws and regulations, just like any Canadian must. This includes respecting health, safety, and labor standards, obtaining any necessary permits, and performing environmental assessments if they are required by Canadian laws and regulations. Finally, to bring the FIPA into force, there is no requirement for implementing legislation or changes to Canada's legal framework. That is, Canada's domestic laws do not change as a result of bringing the FIPA into force. Under a process instituted in 2008, all treaties, including FIPAs, must be presented to Parliament, and parliamentarians are given at least 21 sitting days to discuss or debate the treaty before it can proceed to final ratification. Governments maintain policy flexibility through general exceptions and reservations for existing or future measures that do not conform completely to the treaty obligations. General exceptions apply to the entire agreement. Exceptions cover a broad range of matters, including the protection of human, animal, or plant life, the conservation of living or non-living exhaustible resources, the protection of cabinet confidences, personal privacy, or information related to the financial affairs of individuals, and the protection of essential security interests. Another exception exists for the application of prudential measures in the financial sector for the protection of investors and depositors, the maintenance of the safety, soundness, integrity, or financial responsibility of financial institutions, and to ensure the integrity and stability of a state's financial system. Measures affecting cultural industries are also excluded from FIPAs so that Canada maintains policy flexibility in this area. Existing laws or regulations that do not conform with FIPA obligations concerning national treatment, most favored nation treatment, performance requirements, and senior management board of directors are grandfathered. This means any existing law or regulation at the time of the entry into force of the treaty that would otherwise be inconsistent with one of these obligations can be maintained and does not have to be changed. While such existing non-conforming measures can be amended, such amendments cannot make these measures more restrictive in relation with the treaty obligation with which they are inconsistent. This means they can only be amended in a liberalizing or neutral direction unless they are listed in an annex allowing future policy flexibility. This is an important aspect of Canada's FIPAs in that it provides certainty and predictability for Canadian investors abroad that the investment environment will remain static or improve. That is, the investment environment cannot become more restrictive. It is also possible for a party to a FIPA to reserve future policy flexibility with respect to the following four types of obligations: national treatment, most favored nation treatment, performance requirements, and senior management board of directors. Canada has consistently made a number of reservations with respect to some or all of these obligations, in particular with respect to social services. This includes public law enforcement and correctional services, as well as services to the extent they are social services established or maintained for a public purpose, such as income security or insurance, social security or insurance, social welfare, public education, public training, healthcare, and childcare. Canada has also taken reservations in respect of Aboriginal affairs, allowing for the adoption of new measures providing rights and preferences to Aboriginal peoples. With this reservation, such measures can violate the following FIPA obligations: national treatment, most favored nation treatment, senior management and board of directors, and performance requirements. Therefore, while the FIPA provides for non-discriminatory treatment for all, Canada reserves the right to provide discriminatory treatment, if necessary, for the advancement of rights and policies with respect to Aboriginal peoples. Once the negotiations of a FIPA are concluded, the negotiated text of the agreement is translated into all official languages of the parties to the agreement. As Canada has two official languages, the text will always have at least two equally authoritative versions in English and French. Following this, there is a legal review of the text by treaty law experts. The FIPA is then signed by both parties. Finally, the FIPA undergoes the domestic ratification process of each party. In Canada, international treaties, such as the FIPA, are tabled in the House of Commons for 21 sitting days. During this period, members of Parliament have an opportunity to review the treaty and could initiate a debate. Members of Parliament might also request a vote on a motion regarding the treaty in the House of Commons. For example, opposition parties may use the opposition day to debate and to present and subsequently vote on a motion. After this, an order in council is obtained from a cabinet committee. The order in council provides authority to the Government of Canada to complete steps to bring the treaty into force. Typically, the agreement will enter into force once both parties have completed their internal ratification processes and have informed each other through diplomatic means that they are ready for the agreement to enter into force. Now we will address some common misunderstandings surrounding FIPAs. A FIPA will impede governments, including provinces and municipalities, from regulating in the public interest. A FIPA does not prevent the parties from enacting non-discriminatory laws and regulations in the public interest. Parties maintain their ability to regulate and legislate in all areas, including the environment, culture, safety, health, and conservation of natural resources. Any investor and their investments will face the same requirements with respect to existing local laws and regulations. A foreign investor and their investments in Canada must respect existing Canadian laws and regulations, just like any Canadian must. The FIPA means easier takeovers of Canadian assets. The Investment Canada Act, not a FIPA, governs foreign acquisitions of Canadian companies in Canada. Any foreign investment in Canada, including any foreign investment from a country with which Canada has a FIPA, will continue to be subject to the Investment Canada Act. This means that acquisitions above the applicable threshold will be subject to a determination that the acquisition provides a net benefit to Canada. Also, all investments can be reviewed for national security concerns. Such decisions by Canada under the Investment Canada Act are excluded from challenge under the dispute settlement provisions of the FIPA. A FIPA will allow foreign corporations to sue the Canadian government in secret, closed tribunals. A FIPA provides rights to foreign investors with covered investments in Canada to seek redress for actual damages caused by a proven breach of the specific obligations contained in the agreement. There are very significant tests that must be met before any such claim can succeed. The provisions and procedures for dispute settlement are clearly laid out within the FIPA and allow Canada to emphasize transparency through elements such as public access to hearings and documents. Further, any decision emanating from dispute resolution would be made public. In all its FIPA negotiations, Canada ensures that any disputes brought against Canada are conducted in a transparent manner. This includes the Canada-China FIPA. A FIPA is a secret trade deal that will be ratified with no parliamentary involvement. The Minister of International Trade is directly accountable to Parliament through question period, order paper questions, and the Standing Committee on International Trade. The process for ratification or entry into force of a FIPA is the same for all FIPAs and follows an open and transparent process. In fact, the Government of Canada has brought greater transparency to the treaty review process. In 2008, the government introduced a formal tabling policy that requires international treaties to be tabled in the House of Commons before their ratification or coming into force. The tabling period is 21 days, during which members of Parliament and the public have an opportunity to review the treaty. In addition, members of Parliament have the opportunity to debate the treaty in days allotted to the opposition in the House of Commons. After the tabling period of 21 sitting days is over, an order in council may be approved by a cabinet committee. Once this approval is received, it is posted on the website of the Privy Council Office. Again, it should be noted that FIPAs do not require implementing legislation nor changes to our existing domestic laws. A FIPA is an unbalanced agreement that favors a foreign country and its investors. A FIPA is a bilateral investment treaty designed, first and foremost, to protect Canadian investment abroad by ensuring greater protection against discrimination and arbitrary practices, and enhancing the predictability of the policy framework in markets abroad. In other words, a FIPA allows Canadians to invest with greater confidence. The FIPA includes reciprocal obligations related to non-discrimination, a minimum standard of treatment under international law, expropriation, free movement of capital, performance requirements, and dispute resolution, among others. That is, the obligations apply equally to both parties. In fact, the core substantive obligations are standard in all 24 of Canada's FIPAs currently in force. Our government is committed to creating the right conditions for Canadian businesses to compete globally. Canada's Foreign Investment Promotion and Protection Agreement provides stronger protection for Canadians investing in countries for which a FIPA is in force, and facilitates the creation of jobs and economic growth right here at home. Canada's FIPA establishes a clear set of rules under which investments are made and under which investment disputes are resolved. For further information regarding Canada's ongoing and concluded negotiations and agreements, please visit the website of Foreign Affairs, Trade and Development Canada.